Its, its enactment stemmed from the need to resolve the long-standing issue of landlessness, particularly among Filipino farmers and rural settlers, by democratizing land ownership and promoting responsible land use. So, this is a foundational law in the Philippines that governs the classification, administration, and disposition of lands of the public domain. So, it was introduced to address the persistent issue of landlessness, particularly among Filipino farmers and rural communities, by promoting equitable access to land. So, through mechanisms such as homesteading, sale, and lease of public lands, the Act sought to democratize land ownership and encourage productive and responsible land use. So its enduring relevance lies in its role in shaping land reform policies and promoting social justice by making land and land ownership attainable for ordinary citizens. So let's move forward to the enactment of Commonwealth Act number 141. So following the creation of the Philippine Commonwealth in 1935, Commonwealth Act number 141 was enacted in 1936 to consolidate, streamline, and enhance existing land laws introduced during the American colonial period. So, following the establishment of the Philippine Commonwealth in 1935, Um, this was enacted in 1936 as a key step in consolidating and improving the land laws inherited from the American colonial period. So, its purpose was to create a more organized and accessible system for managing public lands. Importantly, the Act reaffirmed the Regalian Doctrine, so which holds that all lands of the public domain belong to the state. So this is insofar as long as um, such land is legally acquired by private individuals. So this principle that is rooted in the Philippine Constitution reinforced the government's authority over public lands while setting the legal framework for their distribution and proper use. So we now have the legal framework and classification of lands. The Act recognizes four types of lands within the public domains. We have the agricultural lands, we have forest lands, we have mineral lands, national parks. So further classification of agricultural lands is required to determine alienability and disposability. So typically through presidential proclamations or DNR circulars. So, under the Public Land Act, lands of the public domain are legally classified into four main types, each with specific uses and restrictions. So, first, we have the agricultural lands, which are the only type that can be alienated or disposed of. So, meaning they can be legally owned or titled by private individuals. Then we have the forest lands, which are protected areas. Specifically, they're meant for forest preservation and they are not available for private ownership. So, next we have mineral lands. These are areas that are rich in natural resources and are primarily reserved for mining operations and resource extraction. And lastly, we have the national parks. These lands are set aside for conservation and public recreation, ensuring ecological protection and enjoyment for future generations. So it is important to note that even with agricultural lands, further classification is necessary to determine if a parcel is alienable and disposable. So again, this is usually done through presidential proclamations or DNR circulars. So this is to ensure proper vetting before land is opened up, for disposition. So next we have the modes of land disposition under CA 141. So the Act provides for multiple legal modes for the disposition of alienable and disposable lands. So these are tailored to different purposes and profiles of applicants. So first we have the homestead patent under section 12 to 21 of the Act. So this is a system inspired by the U.S. Homestead Act of 1862. This grants up to 24 hectares to Filipino citizens who are heads of families at least 18 years old. And of course, they have to cultivate the land, must reside on and cultivate the land for 5 continuous years. So after the period, a homestead patent is issued, which acts as a torrents title. And last, land is inalienable for 5 years after the issuance and cannot be encumbered within the same period, except with government institutions. So, one of the key features of the Public Land Act is its provisions of various legal modes for disposing alienable and disposable lands. So a major example is what I recently read, which is the homestead patent, covered under sections 12 to 21 of the Act. So this system was inspired by the U.S. Homestead Act of 1862 and allows qualified Filipino citizens, specifically heads of families who are at least 18 years old, to apply for up to 24 hectares of public agricultural land. So to qualify, the applicant must live on and cultivate the land continuously for 5 years. So if all conditions are met, then they may be granted or they are granted a homestead patent, which serves as a torrents title, giving them full ownership. So, however, to prevent land speculation, the law states that the land should be inalienable for 5 years after the title is issued, and this cannot be sold, transferred, or mortgaged except to government institution. So this is during that period. So this is to ensure the land. This ensures the land genuinely benefits those who need it for settlement and prime livelihood. So the next one, we have the sales patent. This is under sections 22 to 32 of the Act. Um, so public agricultural lands not reserved or used for public purposes can be sold to qualified individuals. So land is auctioned unless otherwise exempted. Buyer must pay a minimum appraised value and develop the land within 5 years, and up to 144 hectares for individuals and 1,024 hectares for corporations, which is limited to lease. So this is another legal mode of land disposition under the Public Land Act. So this applies to public agricultural lands that are not reserved for public use, meaning they can be sold to private individuals. So the usual process is through a public auction unless the law provides specific exemptions. So to qualify, the buyer must be a Filipino citizen and is required to pay at least the minimum appraised value of the land. So additionally, the buyer must develop the land within 5 years, which promotes responsible and productive use. So the Act also sets size limits individuals may acquire up to 144 hectares, while corporations may lease but not own up to 1,024 hectares. So the mode allows private ownership while ensuring that the land is neither left idle nor abused. So we move on to the lease under sections 33 to 34. So public land, I'm sorry, letter D, free patent under section 44. So this grants land up to 12 hectares to Filipino citizens who have continuously occupied and cultivated the land for at least 20 years. So they must have paid real estate taxes for that period. And this is only applicable to A&D lands. And this is to simplify land titling for rural farmers. So Section 44, this free patent system under the Public Land Act provides a straightforward way for Filipino citizens to acquire up to 12 hectares of land, particularly benefiting rural farmers. So to qualify, must applicants must have continuously occupied and cultivated the land for at least 20 years, demonstrating the long-term productive use. So additionally, they must have paid real estate taxes for that entire period, showing their commitment and responsibility to the land, toward the land. So this system is applicable only to alienable and disposable lands, simplifying the process of land titling for those who may not have formal titles but have long held the land and have cultivated the land. So this provides a clear path to legal ownership for farmers who have traditionally faced barriers in securing property rights. So we move over to the residential free patent. Um, This extends free patents to residential lands in urban and rural areas. So the lot should not exceed 200 square meters in highly urbanized cities and 1,000 square meters in rural towns. So the residential free patent, which was established by RA 123 in 2010. So this is a significant amendment to the Public Land Act that extends the free patent system to residential lands, making it easier for individuals to secure land titles for properties they have occupied and used as their homes. So this provision is aimed at both urban and rural areas, offering a path to ownership for those who have settled on public land. So the law imposed the size limits that are set at 200 square meters for properties in highly urbanized cities, and then we have 1,000 square meters in rural towns. So to qualify for this, the applicant must have demonstrated continuous occupation and improvement of the land. So this is to simplify the titling process for residents who have lived on public land but may not have formal ownership, helping to provide security of tenure and promoting stability in housing. So we have the judicial legalization of possession. So settlers who have been in actual, continuous, and exclusive possession of alienable and disposable public land since before June 12, 1945, but who lack a formal title, may seek ownership through the courts. So this process is called judicial confirmation or legalization. So for settlers who have been in actual, continuous, and exclusive possession of alienable and disposable public land since before June 12, 1945, but they lack formal title. The Public Land Act provides a judicial process, which is called the judicial ownership, a judicial confirmation or legalization. So this process allows long-term occupants to seek ownership through the courts, essentially formalizing their land rights. It recognizes that these settlers, by virtue of their long-standing use and occupation of the land, have established a de facto claim, even without an official title. So, by going through the court system, they can obtain legal recognition of their ownership, ensuring their land rights are protected and acknowledged under the law. So, this provision is especially important for rural settlers who have um, who have been on the land for decades but never had the opportunity to formalize their ownership due to say historical or legal barriers. So the requirements and restrictions under which we have eligibility criteria. So first, you must be a Filipino citizen, at least 18 years old, or the head of the family. Corporations must be 60% Filipino owned. Applicant must personally cultivate or develop the land. And lastly, natural born Filipinos who lost their citizenship may acquire land, but only for residential purposes. So to qualify for acquiring public land under the Public Land Act, applicants must meet certain eligibility criteria. So the first one, they must be Filipino citizens, either 18 years old or older, or the head of the family. And then the second one, for corporations, they must be at least 60% Filipino owned to be eligible. So additionally, the applicant must personally cultivate or develop the land, ensuring it is actively used and not left idle. An important note also is that natural born Filipinos who have lost their citizenship are still allowed to acquire land. But this is limited for residential purposes as outlined in RA 8179. So this provision ensures that Filipinos who may have lost their citizenship can still benefit from land ownership, but it restricts their use to personal housing, not commercial or agricultural development. So we also have the land ownership limits. Individual maximum, we have 24 hectares for agricultural and then 12 hectares for free patent. And then for the lease to corporations, this is limited up to 1,024 hectares. So under the Public Land Act, there are specific land ownership limits set for individuals and corporations. So again, for individuals, the maximum land they can own is 24 hectares of agricultural land under the sales patent or other applicable modes. So for the free patent system, individuals can acquire up to 12 hectares of land, typically for residential purposes. So when it comes to corporations, they are allowed to lease land up to a maximum of 1,024 hectares. However, it is important to note that while corporation can lease large tracts of land, they cannot own them outright. And the corporation must at least be 60% Filipino owned to qualify for this leases. So this ownership and lease limits are designed to prevent the concentration of land in the hands of a few and to ensure fair distribution. And then lastly, we have the implementing agencies. The following agencies are primarily involved: the DNR, the Department of Agrarian Reform, and then the local government units. So we have several key agencies which play crucial roles in implementing the Public Land Act. So the Department of Environment and Natural Resources is the primary agency that is responsible in carrying out its mandate, mainly through the Land Management Bureau, or LMB, which handles land classification and disposition. And then we have the Community Environment and Natural Resources offices, which work at the local level. So the Department of Agrarian Reform also plays an important role by coordinating with the DNR, especially in cases where land reform initiatives overlap with public land management. And then lastly, we have the local government units, wherein they assist by conducting land surveys, managing tax declarations, and helping with necessary documentation to support land titling and ownership processes. This collaboration ensures the effective administration and proper distribution of public lands. Thank you, attorney. Thank you, classmates.
All right. Thank you, Miss Beronio. But let's go with reality. Ano nangyayari outside of the law? What is
Mm,
happening with um what is happening with um hit mga nag-a-acquire in lands? Actually, may iba nga nakabilinghin lusot hit
mm,
aton hit aton balaod. As you can see, with Miss Beronio's report, may dakit na limit as to how many hectares are we allowed to acquire.
fire.
However, in reality may ito mga sinisiring nga it iba nakaka-go out of that limit because um they are using um different names, kumbaga nagamit hirahin iba, kumbaga hira it napalit, pero ngayon hakamatuoran may dahira underlying nga agreement nga itag-iya hito an usa nga tawo nga naglapos na an iya ownership. May dagihapon na foreigners. Foreigners are not allowed um basically to own or acquire lands here. Pero it iba, it ginihimo, as you can see may mga nagrereklamo gihapon danay hatulpo or may dagihapon haaton courts because it's their money which they have used in purchasing lands. However, um in reality ang ginagamit ang ngaranhan Pilipino. Pero inin diri asyaan kumbaga ang irasabot hagawas ito. Mga sugad ba? May mga solito nga mga istorya outside of the law. Although the law is clear, there are really those who goes out um who finds loophole with the law para maging possible it era may mga tactics para expand it era ownership. Well, beyond that, I just want you to be aware kay um these tactics might be you might experience them in real life or even in the exams. At the same time, um give importance to the different topics Miss Beronio has discussed, especially Regalian Doctrine, the free patent, kay Regalian Doctrine is one of the most important doctrine in natural resources. So if you have any questions, feel free to ask Miss Beronio. I'll give the floor to everyone. Do you have any questions? If none, we can proceed with the next reporter.
Attorney, sorry.
Yes?
I think the next reporter is not yet ready. So the next reporter is me again.
Oh, ikaw. Okay. In taon, sige. And then, kung kaya mo ma-squeeze in it aton, it imo report ano, we can end by the time na mag-end it imo report, tapos we can continue later on. If the next reporter is ready.
Ano daw ba?
Ready ba ano usa? Ano kita ko din eh. He Anthony, ikaw, Anthony it next?
Hello, attorney. Hello, attorney.
Oh,
Ah,
ready ka na? Ikaw
an,
it fourth reporter?
ang next po, i-Apple Joy. Pero nag-chat kasi yung, di pa daw hiya ready. So, ang next
Okay.
nga topic is naka-assign kan Mika and Nestor,
Okay.
Philippine Mining Act.
Sige. So, ano man, amot aton end report today? Or we will continue to the next reporter?
Ah, today.
Sorry, Nestor, kung okay na.
Attorney, uninet ko pa rin na.
Kung ready ang next reporter after Miss Beronio, we can continue this afternoon. But if
Ah,
not, we
okay,
can call it a
ako
day.
ready ako, attorney, for this afternoon na lang. Ito na akong call
Oh, sige,
development.
sige. Sige, sige. Bali, Anthony, ikaw na last nga reporter this afternoon.
Opo,
Tapos we can call it a day.
opo.
Sige, thank you. Miss Beronio and Mr. Margal, you can start.
So we'll be moving forward to the next report.